Hi, my name is Robert Turnage, and today I'll be facilitating this presentation, providing an overview of our agenda and introducing our two keynote speakers. Our last CLE addressed drafting and negotiating master professional services agreements. A related but equally important topic is that of drafting and negotiating order forms, which our speakers will address in this session. This slide lists the main topics that will be addressed by our speakers in this session: work orders, software orders, SaaS orders, and hardware equipment orders. So first, let's zoom out to overview at a high level what our presenters will discuss. First, they'll address what an order form is, the principal contracting document which covers the sourcing of a technology or service. Order form is a broad term encompassing the variety of orders you saw listed on the previous slide. Then our presenters will address how the legal professional, be it an attorney or legal ops associate, should approach the task of reviewing an order form. That is, to ensure that the form contains enough detail to fully cover the transaction and to protect the business interest of the client. A final note on this slide is that this session will focus primarily on the buy side of a technology transaction. We are fortunate to have two highly skilled, accomplished, sought after, and experienced attorneys leading us through today's presentation. Robert Reynolds is the founder and CEO of Tangible. He was previously a partner at multiple Am Law 100 law firms, including Alston & Bird and Seyfarth, where he was CEO of Technology Innovation. After decades as a highly recognized high-stakes corporate attorney, his creative instincts led him to start something new, a company that aims to accelerate legal throughput and facilitate delivery while ushering in a new era of legal pricing models and spend management. His academic pedigree, extensive experience in business and law, and many awards speak for themselves. Suffice it to say, we are very fortunate to have Robert's expertise guiding our discussion today. Alex O'Sullivan-Pierce is an attorney at Tangible and our Director of Legal Operations. A business-focused attorney with an experience across a broad array of industries, including finance, athletic apparel, and technology industries, his accomplishments in the legal world, combined with his unique background as an educator, have quickly made him a key leader and innovator on the Tangible team. Having spent over 5 years as outside counsel with the focus on technology transactions, he's also an expert in the realm of sourcing and procurement. Again, we could spend hours discussing his many accomplishments, but suffice it to say that we are fortunate to have his unique insights and experience contributing to our discussion today.
Thank you for the introduction, Robert. It's great to be with everybody for our CLE today on common issues in order forms, including work orders, SaaS orders, and software orders, as well as a brief discussion of equipment orders. I'd like to begin today's presentation by addressing what might be a bit of a common misconception in the legal and technology worlds, and that is that somehow software order, SaaS order, work order might be less important than other types of contracts, whether they be master professional services agreements, master SaaS agreements, or the like. So we ask ourselves a question of, it's just an order form. How important could that be? And the simple answer is that it's very important. And for reasons that we'll discuss in detail today, you'll see that what might appear to be a simple order form to be signed by both parties really have a lot of moving parts and deserve a great deal of consideration from the legal professionals that are assigned to process such orders. The two biggest reasons that order forms are important are that the fees that are being exchanged between the buying and selling parties are oftentimes not contained in a master agreement, but instead they're contained in an order form. So if you follow the money, as the phrase goes, that'll lead you back to the order form. And when money's being exchanged between the parties, obviously that's a source of important focus and should be always be carefully considered by a lawyer or a legal professional. Because poorly constructed order forms can lead to fee disputes, disputes over overages or renewal rights or term dates. And these kind of disputes or otherwise mistakes in an order form are highly visible to a lawyer's business clients. And so while you might have a master agreement with complex legal terms that's many, many pages longer than an order form, a mistake in an order is more likely to become visible to your business clients. So for that reason alone, they deserve plenty of consideration, as we'll discuss further in our presentation today. So this presentation will mostly cover specific legal and business issues that manifest and arise from the terms that are contained on the page of an order form. But we should also, as business-focused attorneys and legal professionals, consider the overall business context in which an order form is being processed. So the points on this slide basically ask or urge you to kind of consider the overall path of the contracting life cycle and make sure that your transaction in the order form that accompanies it is clear for takeoff, flight, and landing, meaning that it's going to pass all phases of the contracting life cycle without missing any special or important approvals. So specifically from the buy side perspective, you should consider whether the transaction covered by your order form that you're reviewing presently has approval from the buying entity's finance department in any applicable executive review boards. Secondly, you should consider whether all appropriate business stakeholders on your client's side have been consulted about the purchase that will be accomplished through that order form. You should also think ahead into the future about who will have authority to sign this order form. Many times companies have policies about what level of employee can sign an order form of a particular value. So you'll want to consider that ahead of time. So you'll be able to move quickly to execution when the order is fully negotiated. And as a conscientious and helpful legal service provider, you should think throughout these phases of the process on whether your business client needs support in obtaining any of these approvals, if they need a legal summary or need to be reminded to obtain these approvals before and during the contracting process.
Thank you, Alex. Here we'll talk about the types of orders that we will discuss today. Most sourcing programs for the large enterprise might cover 11 different commodity categories or a dozen, 10, but a good number. However, the greatest volume of sourcing dollars, indirect procurement as they call it, really find themselves represented by four kinds of orders. The work orders under services agreements, software orders under the master software license agreements that the client has entered into with software vendors, subscription service orders under the master SaaS agreement portfolio, and lastly, equipment hardware orders. The terms for these types of orders are sometimes vary, but basically you'll usually see nomenclature like work order, program support order, professional services order for orders to source services. You'll find, as we say, software order and subscription service orders for software and SaaS respectively, and equipment orders. The big three negotiating points or review points in the proper support for an order really falls into three different checklist items. There are other areas of the order that matter, but what super matters, what you've got to get absolutely right, is the fees must be clearly defined. You're not looking for estimates, you're looking for true commitment. The T&E can be a little bit different, but even there, you would want to have a cap on fees unless represented by a change order. This helps the client manage the budget, and it helps manage the approval process that Alex described earlier. Secondly, you want to make absolutely certain that your client can get out of the order and understands what rights they have to get out of the order. Generally, most vendors, most providers will agree to a termination for convenience with no penalty. And they absolutely should agree to no automatic renewal of the order. That should be handled by a change order so that the client doesn't look up and find that they've inadvertently signed up to, for example, another year of service under a work order, professional services order. And the client is going to be very, very, very interested in that provision when you get close to the end of the order term, or even if they just decide that the arrangement with the vendor isn't working out properly. And that makes it really important to pay attention to the exit rights. And then lastly, you want to make sure that the provider, even in great good faith, the provider hasn't included ancillary terms in the order that, for example, contravene the robustly negotiated terms of the master agreement. The master agreement is where you should find most legal terms. The orders and change orders are not the place to go modify, for example, limitations of liability. That generally should be, those kind of concepts should be handled by an amendment to the master agreement, not by a concept tucked away into an order form. And you want to look very carefully for that concept. Likewise, you want to pay a lot of attention to any vendor effort to incorporate online terms. That's usually not a terrific idea because those online terms can vary at the vendor's discretion, and it may not properly reflect the understanding that's been reached in the master agreement, for example. So if the vendor wants to include those kind of supplementary terms, then, certainly that can be discussed, but generally the best practice is to append those terms to the order form after negotiating them with the vendor.
Thanks, Robert. So those folks listening at home, you'll hear us refer to those three key points throughout the course of this presentation as the big three. And while everything that we discuss and present to you here in this lesson, we find to be super important. The big three, if you take nothing else from our discussion today, please remember those three big issues of fees, exit rights, and controlling master terms. Those are the big three. So moving on to the process of actually reviewing a draft that comes before you as a legal service provider. As lawyers, we're very excited and to show our skill and value as an attorney through the act of redlining or negotiating specific terms in an order form. But before we do that, it's important to consider the status of the document that you are reviewing. So specifically, you should consider who generated the draft that you are reviewing, and think about how much familiarity that party, the drafting party, has with the contracting process. So is this a draft that came straight from the vendor, or did it maybe come from your client, the buyer? They put this together as a proposal, something they want to buy. And who's contributed to the draft that you're reviewing should inform how you seek to edit or change the provisions that are in that draft of an order. Similarly, you should consider who has reviewed the order so far. And is this being presented to you as a final product of a negotiation between the buying and selling party? Or is this some kind of draft or proposal? Today we're going to list out many important points that should be confirmed and checked off, but how you go about extending that guidance to your client is really going to be dictated by the status of this order. So if your client and the seller have spent many months negotiating the business terms of the deal, you'll want to take that into account before you go in and start changing a bunch of the commercial terms. But on the flip side, you might be asked to participate in the preliminary drafting of an order form. And if that's the case, you should consider if your client needs help or recommendations crafting any specific language that will be presented in the order form that goes to the vendor. So specifically things like renewal options or early exit rights are often concepts that a business stakeholder will have in their minds going into a deal, but they might need your help putting that on the page in a clear way to present it to the vendor. So moving on to the actual text of an order form, you might recall this section from our previous CLE on master professional services agreements, and the points are very similar here. The first place to start your review as a lawyer or a legal service professional is in that preamble. And when reviewing the preamble, the specific points to consider include the parties' names, legal entities, other agreements being referenced. And the task here is to make sure that everything is used consistently, that the dates are correct, that agreement names are correct, and that everything connects properly as it should. An advanced element of this same concept is when a local country agreement or an LCA applies to your order form when the contracting parties are offshore entities, and that will require another additional reference in the preamble. But just as we discussed in our CLE on master professional services agreements, there are, it's common to have mistakes in this section of a order, and those mistakes are highly visible to a reviewing attorney. So although there's no kind of substantive exchanges happening in the preamble, they establish the important governing master terms for an order form, and it really needs to be right. Otherwise, it'll be very visible to a reviewing attorney and possibly a business client. The second point starts in the preamble, but really extends throughout the entire order form, and that's to ensure the consistent use of defined terms and formatting. So, if you define a buyer as a capital C customer in the preamble of an order form, make sure that that's used consistently throughout the order form. Don't switch over to capital B buyer in the second section of the order form. And the final point for this slide is a really sophisticated and complex legal question that's lurking here, unassumingly in a preamble. And that is, when you're referencing a master agreement, you need to make sure that the provisions of those master agreement are current and applicable and adequate to the order form that you are reviewing present. So a specific example of this is to make sure that the privacy and security terms in your master agreement that covers the order form that you're presently working on are current and accurately capture and reflect the type of data being exchanged between the parties. That's a regulatory regime that's fast evolving. So chances are, if you have privacy and security terms that are more than a few years old in your controlling master agreement, those are probably going to need to be updated before you can complete the order in front of you. So important point of focus right there in the preamble. And just to drive the point home, we have here a sample preamble for a simple work order under a master professional services agreement. But just in these few lines, you'll see that there's 6 different elements here that need to be confirmed and need to be right before you move on to any other part of the order form. So you have the title of the order form itself. You have the effective date of the order form of itself. You have the 2 entities, buyer and seller entity, that are defined there. And then you have the controlling master agreement and the effective date of the master agreement. And if Robert and I had a nickel for every mistake we spotted in a preamble in our practice, I don't know, Robert, how many nickels would we have?
I don't know. You could buy more than a large cup of coffee at Starbucks. How about that?
That's I think like $12 these days. So so in any event, the point is that there's often mistakes lurking in these preambles. So don't breeze past it and make sure those are clean.
Thank you, Alex. As we touched upon earlier, one of the big 3, as Alex likes to call them, is no extra legal terms. Generally speaking, the master agreement under which the order form is issued should cover the bulk of the legal terms, and any new legal terms that are incorporated into a order form should be for a specific purpose and well understood by both parties. The order forms, the principal purpose of the order form is to make a particular transaction work, to represent a particular sourcing of goods or services from a particular vendor. That means you're looking for the commercial terms in the order form. Concepts like price and start and end dates, descriptions of deliverables, the service levels that are applicable to a particular order. But generally speaking, you're not going to look to the order to find things like limitations of liability or exclusions from liability or ownership of intellectual property. All of that should be handled in the master agreement. And again, as we touched upon earlier, it is really super important to deal with links to online terms. You'd be surprised at how often you see those, particularly from SaaS vendors and from software vendors that like to rely on their online forms to introduce additional legal concepts that may conflict with or be inconsistent with the understanding of both parties as they negotiated the master agreement. It is possible to incorporate additional terms. But they generally should be represented by an addendum or supplement or amendment, either to the order form or, depending on their nature, if they're more legal in sense, generally represented as an amendment to the master if the customer is even willing to consider additional terms after the negotiation of the master agreement.
So up until now, the guidance we've been covering applies to all types of order forms, be that work orders, SaaS orders, software orders, or equipment orders. But the next several slides that we'll present apply specifically to work orders. So as a reminder, the category of agreement that we're defining as a work order is a order form for professional services. And in an order form for professional services, it's important to consider the following. And I'll start by just telling you that a wise and experienced sourcing lawyer once told me that the first rule of contracting is to establish what are we buying and how much we pay for it. And those, this slide gets to both of those. The next couple slides gets to both of those points. So first, under what are we buying, an order form should clearly define any service, define and describe services and deliverables that are being performed under the order. So you should ensure that the order contains a plain language description of whatever service it is that the vendor is performing. Especially in the business consulting world, you'll find that many vendor proposals are really heavy with industry jargon and abbreviations that are sometimes not defined. If you can, to the extent it's possible, steer clear of this and just go for plain language so that a third party reading the contract down the line can tell what it is that the vendor is actually doing. Might sound like a simple concept, but like I said, the technology industry, specifically, is very jargon heavy, and a lot of times it's the job of a good sourcing lawyer just to kind of cut through that and get to a plain language description. So that's the description of services. The closely related concept is the definition of any deliverables. And deliverables is a very important concept because it usually carries with it considerations for intellectual property rights. Deliverables is often a defined term under the master agreement, and often it means that anything that's classified as a deliverable is going to be owned exclusively by the buyer. So if you're representing a buyer in a work order and you expect to own the output of a vendor's services under that order form, you'll want to make sure to describe very clearly what the deliverables are. And so those are going to be, finished pieces of work product, whether it's a presentation or a report or a piece of code. If the buyer expects to own it exclusively at the end of the work order, you'll need to define those as a deliverable and make sure that that's clearly established under the work order. So on to the second rule of contracting. First rule being, what are we buying? Second rule, how much are we paying for it? We'll discuss here two common and basic fee structures that you'll see very commonly in order forms, in specifically work orders. The first is a fixed fee model, and the second is an hourly model. So under a fixed fee model, a buyer will pay a fixed amount, a fixed price to the vendor for the completion of a certain discrete task, which is a successful completion of a certain discrete task. So putting aside the kind of complex industry of tech consulting, we're going to just seek to develop this concept in a really easy hypo transaction between a property owner and a landscaper. So if you were to contract for landscaping services using a fixed fee model, you could structure that transaction as you see in the first chart here in this slide. You establish milestones and then define what services and deliverables are covered within those milestones, and then there's a price or a segment of the fees for each milestones. So in our first example here, we have the landscaping services divided into the front and backyard. We have, what the specific services are covered, what kind of landscaping needs to happen in the front yard and then in the backyard, and then how much the landscaper will be paid for completing those portions of the service. The second fee structure we'll discuss here is a time and materials, also called, by shorthand T&M, or time and expense, T&E. And this is where you would pay a landscaper just strictly by the hour, by the amount of time it takes them to complete the services. Now, as a buyer, it's very important to establish a not to exceed cap for hourly engagements. So if you'll see in the example we have on this slide here, we have the same transaction as the first example that we did under a fixed fee, but for an hourly fee, fee structure, we have an estimated time to completion of 15 hours. And then that really key concept that the total fees will not exceed $750. So you'll see it's the same services, it's the same price, but it's just structured differently. And there's benefits and there's drawbacks to structuring a transaction as a fixed fee or as an hourly engagement, both for the buyers and the sellers. We won't go too far down that rabbit hole in this presentation, but the point that we need to drive home here is that it needs to be clearly established which model you're going for. If it's fixed fee, it needs to be structured very closely with defined milestones. And if it's hourly, make sure to include that not to exceed cap.
Thank you, Alex. Occasionally, you'll see a different kind of order. What we've talked about here, what Alex was describing on the previous slide, was either fixed fee for a package of deliverables on the one hand, or T&E or T&M, sometimes called, for hourly rates that are bracketed with caps and estimates and those kinds of guardrails. You will occasionally see a different kind of order altogether. And that's what we call a managed service order, which is a package of recurring services that are delivered by the vendor for a particular term, usually to take responsibility for a particular client function or to augment a client function. So the two examples we use here to try and provide clarity around those concepts are, number one, landscaping. Here in our example, the landscaper agrees to cut grass on a particular cadence, subject to certain service levels. Also, a common feature of these managed service orders. In other words, the vendor agrees to perform according to certain performance metrics, and if they fail to meet those metrics, they'll pay a service credit of some kind. They also often will agree to what clients will call KPIs, or key measurements. KPI meaning key performance indicator. And those are not subject to service credits, but they do come with a commitment by the vendor to do their utmost to meet those metrics. In tech outsourcing, which is what you commonly see for large enterprise clients, the vendor will agree to a package of services subject to certain service levels, often, not always, but often having to do with help desk, or what they call level 1, level 2, or level 3 support for particular IT operations that are run by the client. And that will come with coverage commitments. It will come with service levels. It will come with service credits. They can be, in some senses, a variety of outsourcing transaction, not the 200-page outsourcing agreement that are associated with the really complex, more global, comprehensive outsourcing arrangements, but instead a different variety where you find the bulk of the legal terms other than service levels in the master agreement, and the managed service order can ride as a companion piece to the master agreement, because the two taken in combination provide the client with all of the legal terms they're looking for, like IP ownership and limitations of liability and those kind of concepts. And the managed service order goes on at some length to describe the package of services, service levels, usually a fixed monthly charge for delivery of those services. They can be a fairly complex transaction that require super attention to meet the client's expectations. Often the vendor is taking over a fairly critical function in delivering that level 1, level 2, level 3 type support. And it's really super important to get it right, to get it detailed, and to meet the client's expectations.
RT, if we could go back to that just briefly. Robert, I think you'd agree that, the managed service model is an advanced fee structure where those terms and the parameters and the KPIs and service levels are often established in the master agreement. And so the key when reviewing an order form is to make sure that you don't have a service that's styled as a managed service, but then is not supported by the terms in the master agreement. If for regular fixed fee or hourly, all those terms will just be kind of neatly contained within an order form. But for managed service, that's going to really require a lot of extra terms that need to be present in the master agreement.
Yeah, totally agree. Good point, Alex.
Thanks. So, I'm sorry, Robert, go ahead.
Oh, I'm happy to have you handle it, Alex.
No, this one's yours. Go ahead.
As we talked about at the very beginning, Alex's big three principles include getting exit rights correct, and make sure that the exit rights meet the client's expectations. That job starts with clearly defining the term in the order. Sometimes you will see ambiguity in that term, not so much with the start date, even though even that, the effective date of the order sometimes will differ from the start date of the service package. And occasionally, particularly in managed services, you will find several phases before you get to steady state. Those phases, generally speaking, feeling like a transition phase as a vendor takes over the function, a stabilization phase as a vendor moves out of transition and starts to deliver the services, and then finally steady state where the vendor is delivering the services in a routine fashion when the service levels kick in. So the start date is important, but a companion piece to that is making sure you understand the phases in which the vendor will operate. You also need to know and set forth clearly, what is the end date? And that sounds simple, but often, particularly in managed service orders, you have to ask yourself the question of, are they trying to end the term at some anniversary of one of the phases? For example, the beginning of the stabilization phase or the end of the steady state phase. So you really have to work with the client to get those right. And if you don't, if that doesn't happen properly, the vendor may overcommit in the service package they deliver, or the client may overpay or underpay for that service package. So there's more complexity to that concept that might seem obvious from a quick look. The related concepts are a clear and accurate delivery schedule for the completion of services and deliverable milestones. it's really important to encourage the client to get those dates down crisply with the provider so that those expectations are clear from the outset. If you get 6 months into the order and the client believes that the vendor has under-delivered, or the vendor believes that they have over-delivered, and the order doesn't clearly, settle that issue, there's an opportunity for a fuss between vendor and client that's just unnecessary if we get that right. Similarly, for those orders like fixed fees that cover projects, really important to know what the project phases are. We touched upon that a little earlier on this slide, but this is a bit different because we're talking about here a committed project to be delivered by the vendor, not a managed service that will continue over the entire life of the contract. And the key to get those project orders right is real clear understanding on what the project phases are and what the milestone dates are for the delivery of those phases. Similarly, you'll want to make sure that the payments that the client has agreed to align with project milestones. Sounds simple, but if, for example, the client is supposed to make a payment, a significant payment, before delivery of a milestone that's associated with that payment, the client may then be committing to making a payment for a milestone that's not successfully completed by the vendor. And that also can lead to a fuss between vendor and client and disappointed expectations on the part of the client. It's also important to understand if the vendor, as often happens, that the vendor has actually started work before the order comes into effect. There are two different tactics that companies adopt in dealing with that issue. One is to establish the effective date of the order as at the time that the vendor actually started, even if that date is far earlier than the date the order is signed. We think it's far better practice to establish the effective date of the order as the date it's signed, and then do the proper drafting within the order to indicate that the vendor started earlier and has either already been paid for the services delivered before the order date, or is going to be paid under the terms of the order for those services. That we think is cleaner contracting, but companies do it both ways.
But that in either case, the work the vendor performed prior to executing the order would be covered by the terms of that order and any control.
Well said, Alex. It's a great point.
And this is just a reminder that while the state of Oregon does not require a certification code, if you are in a jurisdiction that does require certification code, the code is all caps tangible _ orders, all caps tangible _ orders.
So that closes out our specific discussion of work orders under master professional services agreements. In the next several slides we'll present to you today are going to cover software orders, which are generally executed under master software license and services agreements. So returning to that first rule of contracting, what are we buying and how much are we paying for it? It applies to software orders just as it did to work orders. So when reviewing a software order, you should really first ensure that that order form contains a detailed, adequate and plain language description of whatever software products are being purchased under that order. You shouldn't rely on any kind of product catalog numbers that relate back to a vendor system or any kind of SKUs that you might see get pushed in a vendor generated order form. It's important to really to focus on the specific software titles that are being covered by a software order form, and make sure that those end up in the order instead of any kind of shorthand that might appear in a vendor quote or an initial draft. And secondly, if that software order form contains any professional services component, then essentially all the considerations of a work order apply also to the software order. So make sure that terms, start and end dates, and any delivery dates and deliverables or milestones that are a part of those professional services that accompany the software order are clearly defined in that order.
And sticking, Alex, with this slide for just a moment, do you think it's common for the software vendor to agree to that additional development activity? And if so, where do you see that happen?
I guess the most common areas of kind of accompanying professional services for a software order are things like training the buyer's organization to use the software. Other common areas are implementation or customization of those software products to fit the needs of the buyer. And I know we'll discuss several of those a little bit later in the presentation today.
Thank you.
So moving on to an area of focus that is really specific to software orders and really doesn't apply to work orders. It's highly important to focus on and define any kind of usage limitations or user counts that apply to a software order. Oftentimes vendors, are going to seek to limit a buyer's use of their software. And the two principal mechanisms they use to do that are one, user counts, and then two is use case. So sometimes software is provided to a buyer under the condition that it's only used for a certain use case. For instance, this software can only be used for a buyer's North American operations. And if the buyer wanted to use the software to support their global operations, that would be a different licensing. So that's a simple example of a kind of use case limitation. The second limitation is the concept of authorized users. And commonly, a software order will only cover a certain number of authorized users. And in addition to the number of authorized users that is covered under a specific software order, it's important to focus on the definition of authorized users and which type of buyer personnel can be included in the definition of authorized users. So, as is their prerogative, vendors will seek to kind of narrow the scope of applicable authorized users because, they want more potential customers in the future. But a buyer, especially if it's a big company, will really want, and oftentimes they'll sort of operationally need a broad definition of authorized users so that those authorized users encompass personnel, including employees of affiliated or subsidiary companies, and also contractors or consultants that might work as integrated parts of the buyer team. So when you are reviewing a software order, it's important to focus on these two types of limitations and make sure that they are acceptable and understood for your buying client. Make sure that the use of the software that the buyer intends is going to be within the scope of the allowable use, and make sure that they're buying enough seats for their authorized users, all that they need, and make sure that everyone they want to be counted as an authorized user is allowed to be counted as an authorized user. And the final point here is that the failure to clearly understand or establish these limitations in a software order can result in fee disputes, which is never a place we want to be.
So thank you, Alex. Concepts that are very closely related to Alex's discussion in the previous slide is once you know how usage is defined, then you're going to know how do I pay for that usage. So it's really important in software orders, and it can be very complex to get this done. It's really important in software orders to get clear per unit pricing, or however, whatever the vendor's pricing strategy might be. Generally speaking, the client is not going to have a whole lot of influence over the vendor structure. They may have for pricing, they may have a ton of influence over what they're ultimately going to pay, but they're not going to be able to guide the vendor into a different pricing structure than they usually provide in most cases, absent a really super special deal. But in any event, you want to understand that pricing structure, and you want to make sure that the order clearly reflects what the client expects to pay within that pricing structure. And perhaps as important is to make sure the client absolutely understands what that pricing structure is and what they're going to pay underneath that pricing structure. The companion point to that is what happens, in Alex's discussion, what happens if there are overages? If the client ends up with greater usage than they anticipated on the front end, how is the client going to pay for that usage? And there are any number of different ways to price for excess usage, including what they call volume bands. There may be per unit above a particular usage tier, any number of different ways of doing it. But it's important to have some kind of concept in the order, at least in most cases, that allows the client and the vendor to understand with crispness what the buyer is going to pay in the case of excess usage, however that is going to be structured. Likewise, the buyer may experience corporate events that cause them to want to add additional users during the term at a particular price or roll users off. And here we're talking about major corporate events like an acquisition or a divestiture. And the order should have some kind of indication of what happens for those major corporate events. And finally, a feature that you will often see in software orders, and as we'll discuss also in SaaS orders, is some kind of reconciliation at the end of a particular usage period. So the client may pay a particular tier price. For example, they may say, I'm paying $100 for 1,000 users on January 1. Then they get to the end of that usage period, let's say June 30. And vendor and client look at what the actual usage was as compared to the projected usage for that usage period. And they'll have a so-called true up or reconciliation of that actual usage. If the client is used far more vendor capability than expected, like they put 5,000 users on the platform, or on the software in this case, they'll pay up with some kind of true up payment, reconciliation payment. If occasionally, if they've used less than the expected demand, they may be entitled to some kind of credit or other reduction in fees going forward, or in the rare case, even to a refund for the vendor. Although vendors like to give refunds about as much as they, like to eat broccoli or something. So look for those true up mechanisms, make sure the client knows how they work, and make sure that the true up trigger isn't a surprise to the client. When the client finds out on June 30 that they've got to pay another $200 for excess usage, and that's a surprise to them, that's usually not a good experience.
While the true down isn't commonly found, although Robert, you said it does exist, a common kind of buyer-friendly true-up mechanism is one that allows the buyer to not pay the fees for the increased usage until maybe the end of their current term. They don't have to pay for the ones that they
That's a good point.
or during the term, but instead it'll defer those payments over to the next cycle.
Yep, good point.
So speaking of cycles and term dates, we arrive here to the topic of term and renewal for software order. For software orders, this topic relates closely to our discussion of the importance of reviewing effective dates in the preamble. It also connects to Robert's discussion of work schedule dates and delivery dates for work orders. And for a software order, the considerations are conceptually very similar. Most basically, you should establish the clear start and end date of the software license that's being procured under the order form. And the kind of advanced and related concept to consider is the right for a buyer to renew that license at a predetermined price. And in order to kind of gauge how much attention and detail to give to the issue of renewal, it's really important to consider the key concept of how critical is the system or the software product that's being licensed under that order. If this is a business critical key piece of technology infrastructure that's being covered under a software order, your buyer client is going to really need assurances that at the end of this software order, the vendor isn't going to turn around and either pull the capability because they're moving on to some other product or jack the price, unreasonably on your buyer client. So the way to protect against that is to establish key renewal rights, clear renewal rights. And oftentimes the vendors will be on board with this because generally vendors want customers renewing and continuing their relationship. So vendors will be willing to a point to agree to make it convenient and easy and smooth for a customer to sign up for additional terms and ensure that business continuity. So in addition to kind of establishing exactly what renewal rights and pricing your buyer client has, you need to also consider what the method is and the process is for exercising those renewal rights. So sometimes you'll find an order that might require the vendor to issue a notice to the buyer 30 days or 60 days in advance of the end of that, the term of that order. And that gives the buyer the opportunity to take that renewal invoice and pay it, thereby extending the term of the license for another 12 months, for example. And these are flexible. Nothing is set in stone or concrete that it has to be a certain way for the buyer and seller. What's important is that it's clearly established and that that both parties understand how the process works.
Thank you, Alex. That concludes our discussion of software orders. We're now going to turn to a closely related technology, which is SaaS technology. The enormous difference here, and it makes all the difference in how to think about these relationships and how to structure the order, is the software orders are for on-prem software that is on-premises software that's going to be installed on the client's boxes and that the client largely will manage after installation with some visibility by the vendor. By contrast, a SaaS relationship is technology that is running on vendor boxes that the client accesses over some kind of usually high bandwidth pipe, an internet interface, for example. And the fact that the technology is running on vendor boxes and client data gets put on those vendor boxes makes all the difference in how you think about those orders, although several of the concepts we talked about earlier also are germane to a SaaS engagement. As with software, it is super important that the concepts that define usage rights are clearly set out. They're crisp. They're well understood by both client and provider. And again, there is many different ways to set up those usage rights, as limited only by the provider's imagination. Generally speaking, the client's not going to have much of an influence over how the vendor defines usage. They will often have great influence over what they pay for that usage, but not how that usage is structured or how the pricing model is determined. As with software, a SaaS order, often can include both the technology component. What does it cost me to actually access and use the technology provided by the vendor, as well as bolt-on service commitments by the provider. And those often will be packages like training, customization, sometimes a reskinning of the product. But the SaaS order will cover both components, and the master SaaS agreement will, as we discussed earlier, provide the legal terms for both the technology relationship and the service relationship.
Robert, just as a tactical point, in reviewing a SaaS order, one drafted particularly by the vendor, oftentimes it can be difficult to tell exactly what it is that the buyer is getting under an order form, especially if the vendor has multiple products. So again, this might sound very common sense and tactical, but simple Google search and cruising of the vendor's website is often a really valuable step to see what service offerings this vendor actually has and which one your client is signing up to. Just because oftentimes the order forms can either be vendor shorthand, that can be imprecise, or they can kind of conflate the name of the vendor with the name of the vendor's products in a way that's can get confusing down the line. So Google is your friend.
Yeah, that's an excellent point. I mean, take those really super large enterprise providers that have shifted to the cloud, like Adobe, for example, has 250 products, they all accessible by the cloud, or most accessible by the cloud, and understanding how Adobe, SAP, Oracle organizes those capabilities and how they like to sell those capabilities can give you a real head start on getting to a good and strong order with that provider. As with software orders, it is super important that the SaaS order clearly define usage limitations, user counts, what the guardrails are around the client's ability to access the platform, what happens with excess usage, is there a cushion for excess usage, what's the pricing impact for usage that either materially falls short of the expectation or materially exceeds the expectation when going into the order. But all of those should be covered in the order and clearly set out, just as we talked about with software orders.
And also, very similar to the points that we covered under the software order section, pricing for a SaaS subscription order is often based on some kind of usage or per unit price. And it's really important to make sure that your order contains not only the total price, but a very clear per unit price and a definition of what those units are. Robert and I have often been discussing, common units that you use for pricing, like users or seats. but some SaaS products are priced based on very different metrics like clicks or views. Some products are provided to buyers at the enterprise level based on the size of an enterprise. And that could be measured by number of employees or gross revenue of the buying enterprise. So whatever it is, establish what the units of pricing are and make sure they're clear in your order form. That will enable kind of a clear and smooth calculation if there are any overages during the term of that order and what the pricing for those overages will be. It will also kind of set up a clear negotiation of any kind of rights for a buyer to add additional users during the term of a order for an established price. And as Robert discussed for software orders, the mechanism of kind of adding or subtracting in the total usage of a SaaS product during the term of an order is commonly referred to as a true up or a true down. And there are several ways to structure that. Important point is that it's clearly defined somewhere in the master agreement or the order form how those equalizing fees are charged and when they're charged to your buyer.
As with software, really important in SaaS orders to understand what the term is and back to Alex's big three, what the exit rights are and what the renewal rights are. And let's talk about practical cases. Why does it matter? It often gets particularly important with startup vendors or young companies where the client has agreed to try out a particular technology that is offered by the vendor in a SaaS model. And the question there is, number one, what happens if the client is dissatisfied, if they're not happy with that technology? And although we make this point in the case of younger companies, it's equally true with larger companies. Does a customer have a right to get out before end of term? That is a point that really needs to be seriously considered in almost all SaaS orders. Can they exit for convenience before the term ends? Vendors hate that. Strong word. They robustly resist an early out, but they can be available and they can be negotiated, and they are a worthy objective. Similarly, you should understand, and the order should reflect what happens at end of term of that order. Are there renewal rights? Often there should be renewal rights, and if there are renewal rights on the part of the customer, what's the pricing and other terms that are applicable to those renewal rights? But most importantly, what is the pricing that is applicable to those renewal rights? Alex and I are not big fans of automatic renewal. We'll touch upon that a little bit later, but by contrast, giving the customer the right to renew at their option, we really get excited about. We think that's good practice if it's available in any particular SaaS order.
So here's a complex topic that we're going to just touch on briefly here, and maybe it's a tease for a future CLE presentation dedicated solely to this topic. But here we'll briefly discuss the issue of IP considerations for software or SaaS configurations. So this comes up in a scenario where your client buyer is paying a technology provider fees to customize that technology specifically for the buyer's use. And the question is, who should own the rights to those custom configurations? And there's no easy answer to this, but rather we want to just outline the kind of considerations that both the buyer and the seller will have in this scenario. Buyers should reasonably be able to expect that if they pay a company for their time to customize or produce a certain customized product, they should expect, if not outright ownership of that customization, at least an exclusive use, or at the very least, an assurance that that technology provider isn't going to turn around and shop that customization to a buyer's competitors. But on the other side of that coin, a technology provider is going to be very, very resistant to giving away any kind of IP rights that even get close to their core product. So just the simple fact that a buyer paid a tech company a few extra dollars to create a custom interface or otherwise tweak their product so that it's better for the buyer's use, the tech provider, the seller, doesn't want that to then give away their core IP and limit their ability to sell their product to other customers in the market. So those are kind of the core tenets here. Robert, if you have any other additional.
I think you make the most important point, which is when the buyer goes in to try and secure ownership as compared to license rights to customizations, that's often an opportunity to bang your head against a wall for the next 3 months and to slow down the closing of the transaction. It generally speaking is not going to be easy to do. And generally speaking, there's not a particularly good reason to do it so long as you get appropriate protections against availability of those customizations to buyer competitors. So we generally are pretty flexible and pretty amenable to a vendor position that they need to retain title to customizations, particularly as Alex points out, surrounding their core product. That, it's not for the faint of heart to go in and try and have that negotiation if you're really seeking ownership. The last category of order that we'll talk about in this presentation are equipment and hardware orders. And what we would have you understand here is that there's an enormous difference between a buying order and a leasing order. And the reason for that is because the terms of a leasing order are driven by the financial model that supports the lease. And that results in several almost non-negotiable terms that show up in the lease. For example, the buyer must pay, period, the lease payment, regardless of what else happens. That's because the vendor is going to turn around and sell that leasing paper, usually to some financial institution. And in order to sell that paper, they've got to have clean paper and clean rights. That makes an equipment lease a very difficult and complex transaction, not difficult, but complex transaction where you have little opportunity to negotiate except around the edges. On the other hand, an equipment purchase is like going to Best Buy, at enterprise scale and buying boxes of some kind or monitors or whatever else it might be. Usually not too complex, usually covered by appropriate warranties and appropriate return rights. And, not to be trivial about it, but the same kind of experience that you would have if you bought the new Apple laptop from the Apple store. You take it back, it's supposed to work right, all of that, as compared to leasing, which is like leasing that new BMW and everything that you sign up to when you sign that lease document, exactly analogous.
Coming to the end of our presentation here, just thank you for sticking with us and covering a lot of ground here. So we just wanted to kind of bring us back and focus as we close out our presentation on a few key takeaways and core principles. And the first of those is to kind of remember to identify and ground yourself in the type of order that you are working. because as we've outlined and organized this presentation, the type of order, what you're buying, is going to kind of dictate what the important elements are of that transaction. The second point of focus here and key takeaway to remember is how much are we paying? And make sure you're confirming those commercial terms and focusing in on defining a fee structure. And then finally, as we said, nothing else from this presentation, do remember those big three issues that apply to all classes of orders. And those are exit rights, pricing and term, and no additional legal terms snuck in there by a vendor.
Right, and because we don't have the luxury of an in-person Q&A, I'll be asking some commonly asked questions, and Robert and Alex will be answering. So the first question is, can more than one type of product or service be ordered under a single order form?
So I'll take that one. The answer is yes, with the caveat that the master agreement covering that order form needs to cover both types of products and services. So a common miss in this area is for a vendor to kind of like throw in hardware purchase or hardware items along with the software license, but you need to make sure you're checking in the operative master agreement, because if there's no terms for the purchase of physical goods, then that purchase isn't going to work under a single order form. You'll need to break it into two order forms. So the answer is yes, but the master agreement has to cover both types of products and services.
Right, and the second question is it ever advantageous for a buyer to agree to auto renewal?
Alex, would you like me to take that one?
Please.
So the answer is yes, but a qualified yes. And what that means is this. The number one, the buyer should always have the right to prevent the automatic renewal. Secondly, buyers often resist having to remember that they've got to opt out of an automatic renewal. Therefore, they resist the concept of an automatic renewal and in favor of the option on the part of the buyer to renew within a certain framework. That's usually the preference, which means that if the buyer is going to agree to an automatic renewal and the housekeeping burden that comes with the automatic renewal, they ought to get something in exchange for that. Better pricing for the renewal term, something, discounted pricing, additional usage rights, whatever it might be. But it's a concept that the buyer can agree to, but they need to be incented to agree to it by the provider.
Yeah, and for this issue, once again, and always, it's important to consider what it is that you're purchasing under that order. If it's a mission critical piece of technology, an automatic renewal might actually be okay for your buyer client. But if this is something that's kind of a secondary, accompanying piece of technology that the buyer might just forget to renew or cancel and then incur extra fees, then they're not going to want automatic renewal. So just as always, business context can inform the discussion of that issue.
Great. And the third question is, why are equipment purchases less complex than equipment leases?
Alex, you want me to take a run at this one since I had equipment orders?
Yes, please go ahead.
So we touched upon this as we talked about equipment orders, but the basic answer is when you're buying something, it is going to Best Buy and buying a television. Everybody understands that transaction, pay for it, product comes in, product needs to work, product is covered by a warranty of some kind. If it doesn't work, it goes back. That's simple, straightforward, easy to do. The equipment leasing, on the other hand, really is a financing document. That's what's not usually clear from the face of the equipment lease, that it's not so much a transaction to to acquire or source a piece of hardware. It is a transaction to finance a piece of hardware. And that makes all the difference because you end up with largely non-negotiable financial terms that are intended to protect the vendor's ability to sell that paper to a financial institution of some kind.
Great, thank you so much. And this is a final reminder that to receive CLE credit in Oregon, first send your name and 6-digit bar number to my email, rturnage@tangibleltd.com, and then log into your member dashboard and add the activity to your transcript.
So finally, thank you everybody for joining us for today's presentation. We enjoyed discussing these topics with you. We look forward to our future presentations and hope that you will reach out to us with any feedback. Thank you, and we'll see you next time.